is part of Article 21. It is a fundamental right, and everybody should have some right to protect their privacy. And to what extent that privacy can be compromised was a question which was deliberated by Puttaswamy, and we all know what has happened in this case. So this is case Puttaswamy 2017 is the reporting, and if you see, these were the judges who gave the opinion in this. The majority opinion was written by Justice Vice-Chancellor, and very well written judgment. I was reading the judgment the other day, and I see there is a lot of scholarship in that judgment. If you have a look at it from students of law, I believe everybody should read that judgment in detail, including all concurring opinions of different justices, because on the same point they have given different kinds of arguments. So I implore upon you as students of law that please have a look at that particular decision in detail, read it, because there are quite nice arguments put up from both sides. And if you have to read the state's argument on privacy, that is also very important, Tushar Mehta's argument, and the judgment actually lists the argument by different counsels. It is quite interesting to watch for those particular arguments and how. I have called out two propositions from this particular judgment which I wanted to present to you, which interested me a lot, and one was relating to informational privacy, because that is something which actually laid down the foundation for Digital Data Protection Act, because that decision, probably Rohinton Nariman, Justice Chandrachud and Sanjay Kishan Kaul, these were the judges, in their opinion, they talked about informational privacy. And this is the informational privacy which concerns has been addressed in digital data protection law. So when Justice B.N. Sri Krishna took over as a committee, and they gave a detailed report on right to privacy, particularly in the digital space, and the need for data protection and digital privacy, they referred to this informational privacy in Puttaswamy's case. So if you see the impact of Puttaswamy's case, the impact is multifold. One of the impact was that it also overruled partially the ADM Jabalpur's case, because there also the restriction by the state was upheld in this particular case to an extent, and on specifically on the privacy perspective. So this was dealt with in this case. And another very important aspect which this decision talks about is the human element of life. So it has defined life, though life got defined in many of the decisions, and primary one being Maneka Gandhi's case, and then subsequently many other decisions. And this particular decision talked about that human element. So it is important to focus on that human element, because whenever we are talking about rights, restriction on rights, then that human element shall come up. That is the dimension which has been talked about in this case. This case is also very important from a perspective of additional rights getting recognized. So if you see, this case opens up the debate on the LGBTQ rights, and then subsequently if you see the right of women, particularly the differentiation on the grounds of adultery, that is what is the case which is referred to as Joseph Shine versus Union of India. So these cases actually emanated from that argument of privacy. Interestingly, if you see the Justice D.Y. Chandrachud's judgment, he is also talking about, toward the end, about criticism of privacy. So that is also a very important part which I feel the student should read. And in that, there is one portion which is talking about feminist jurisprudence. And he focuses upon that how this feminist jurisprudence or the right to privacy is a breach of women's rights, in a sense, because on the grounds of privacy or on the pretext of privacy, you are exploiting women at some places. So this is something which has been very, very forceful argument in that particular decision, and I believe this opens up much more larger dimension of arguments and debates in Puttaswamy's case. So you may be thinking that I'm teaching you Puttaswamy today, I will deal with DPDP Act or not. But this background is important because this sets the base for your DPDP Act. Because I will tell you today, because this law is yet to be enforced fully, you will see catching of petitions in High Court, Supreme Court, and this is the future of what you can say litigation in the country. So coming 10 years, just imagine that every order of the Digital Data Protection Board or maybe someone who is taking on privacy or breaches, these are all going to courts. And when they are going to courts, they are going to be interpreted. And every time Puttaswamy will be picked up by the judges and they will be trying to find sense in it as they are doing right now with Keshavananda Bharati. So everywhere, wherever there is a conflict between judiciary and executive, they pick up Keshavananda Bharati and support the argument. This is what is going to happen with this case. This is a very landmark case which we should read again and again. Because I have read it 2 times, but every time I read, I find something new in that is quite interesting. Let me take you to the this particular thing I was referring to. It is talking about typology of privacy, right? So it is an article which is by Popes et al. And this is by University of Pennsylvania. This is a character of Justice D.Y. Chandrachud's decisions. You will find a lot of quotations coming from USA. Probably he studied in Harvard and he is used to reading a lot of articles from there. And in his judgment, you will find a lot of references from US. And, there is a critique also to it in public domain. If you find out that whether we should get influenced by the decisions or by the articles in US, because that is a different society, we are a different society, whether we should import those values and those principles into our society is another question, which I leave it to you for a different day. But here, if you will see this particular slide, it focuses upon the different dimensions of privacy. To what extent the privacy can be open to public and to what extent you can have the complete privacy of things. In broader frame, we are talking about informational privacy. So now, privacy is a question which depends on person to person. That is what is my belief, because I see social media, a lot of social media, where you will find that we post everything, each and everything, we don't shy away from posting anything. So if you go to social media, you will find anything, including personal moments, including all kinds of stuff you will get on social media. Then I question myself that whether we are talking about privacy or whether there is a need for this, or we are just, it is a fad kind of a thing. No, privacy, or it is a jantar mantar privacy probably. So, but that is something which is quite interesting to argue about. Now, when we talk about privacy, these two gentlemen are very, very important, okay? So, one on the right side you see is Nandan Nilekani. He was the person who came up with this idea of Aadhaar. And later on, he got this proposal and the present government lashed up that proposal, and you see the Jam Trinity, which is there, that is Jandan, Aadhaar and mobile, that got a huge success. Initially, it was questioned whether it will be successful or not. But you all know that how the digital payments and how the Aadhaar has been successful in direct benefit transfer and how it has contributed to the lot of people in the country. If you look at it, leave the politics aside, but if you see the ground, how it has helped people, there are challenges, but it has helped people around. So this Aadhaar has become a very, very important, such a important, initiative. So Justice B.N. Sri Krishna, he is again one of the judges of the Supreme Court. He retired. He was part of a lot of committees. One of the committees talked about unification of regulators. If you recollect, that is FLSRC report. A long time back, he was the chairman. And he was an erudite man. And he gave this particular report on data privacy, and whatever DPDP Act you see presently is the push of this particular report, basically. So you can read something more on this. So this is Digital Data Protection Act, And if you see the preamble of the law, it talks about having an agency or having a board which will take care of the data of people, because we are having so much of data we release, both in physical form as well as electronic form. So data protection law does not discriminate between data which is in physical form and electronic form. So even if data is collected in physical form and it is digitized later, all that particular data comes under data protection law, right? So this law is there provided to give you, information, give you the protection from breach of that particular data. That is the basics of Data Protection Act. There are certain things which are defined in the data protection law, and one of the important definitions which is there is of data. And it defines data, and it says data means representation of information, facts, concepts, opinions, or instructions in a manner suitable for communication. So it is something which must be suitable for communication. It cannot be a data which is encoded, encrypted. Those data cannot be considered as data in this particular part. It should be part of a communication, interpretation or processing by human beings or by automated means. So it includes the perspective of automated data processing as well, by way of a system or by way of a mechanism, or you can say nowadays we are talking about artificial intelligence and technology to process that particular data. And automated here is basically meaning any digital process capable of operating automatically in response to instructions given or otherwise for the purpose of processing data. And the question is, the next question which comes to our mind is that data applies, or where the law applies. Law applies to whom? Who are the people to whom the law will apply? The law applies to the whole country. All of us would be subject to this particular law. All citizens, everyone will be subject to this particular law. However, there are exceptions. It will not apply to certain situations, and that is important to note. If you see, it is not applying to personal data which is processed by an individual for personal or domestic purposes. What do you mean by that is again a question. This will be subject to interpretation subsequently. Like, I can give you an example, whether a data shared by a husband and wife, or I should not use this term husband and wife, I should use spouse, right? That is better. So whether the data processed by spouse for domestic purposes would be considered as a personal data, or if, say, for example, that data is utilized, and I was reading today's newspaper, only Delhi High Court says that you cannot have RTI information, you cannot have the salary slip of the spouse for maintenance purposes in the court under RTI, because that is the personal data of that person. So this is a question which will be coming up. So what will be that personal, what will be that domestic is a question which has to be looked at it. Then it says personal data that is made or caused to be made publicly available by the data principal to whom such personal data relates, or any other person who is under an obligation under any law for the time being in force in India to make such personal data publicly available. So these are the two things. Imagine a scenario, if it is a government servant, government servants are required to make certain data public, right? Like, for example, election, when someone goes for election, they have to fill the election forms, including their educational qualification or maybe income they are earning. All those particular data will be publicly available. Can they say that their data is protected? No. Why? Because it is by law it requires to be published to the people. Now many people say, my personality right? Nobody should breach it. No, but again, you are a star. So you expose yourself, your privacy by way of that. No one should misuse that. But again, you cannot claim complete immunity that nobody should trouble you. So if you are on the road and you are a celebrity, people are going to be flocking you and you have to face that particular music. So this is something which is, a dilemma which happens with these celebrities, and probably here this is talking about that. Second, if data principle themselves, who is the data principle? We all are data principles, right? So under the law, every one of us is a data principle. So when you own the data, your data belonging, your personal data, you are the data principle, and you have certain rights and certain obligations. Under this particular law, one of the thing is about consent, and another thing is if you put something publicly, you have already put it on social media, then you lose that particular privacy, right? So this is what exactly the example also says. So if you see this illustration, it says X, an individual, while blogging her views, has publicly made available her personal data on social media. In such a case, the provision of this act shall not apply, right? So this is the gray area, this is a question mark. I don't know how this is going to be interpreted, but a lot of issues will come around there. That to what extent the information which I post on social media will be subject to public scrutiny or utilization by public scrutiny, or to what extent I can protect it. So this is something which will be a very crucial question, which I believe every one of us should be questioning and asking. So please, keep a mind to that, as well as keep a mind to your social media posts. So be careful what you post on social media, because once you post something, you are giving consent. So that is very important. And I don't know whether you people have read the agreement with Meta and the agreement with Instagram. Probably when you are using Instagram, I don't know how many of you read the agreement with Instagram before posting the photographs. But I'm sure that nobody read it fully. Maybe as a law student, you may be intrigued and someone is doing a project on it. I can understand you would have read it. But as a user, as a data principle, I doubt that anybody, I have not read it, but I am active in social media, but with the risks, now I am reading it, so I am thinking about it, that whether all this information which I have given is of, protected or not protected, or is there any, challenge to that? This is something which I am thinking about it. So you got the context, so it applies to whole of the India, and it will affect everyone. But my concern is larger, we are sitting in an elite audience. I'm sitting amongst elite audience. I call you all elite. Don't get offended by that, okay? We are all elite because we are sitting in a good comfy room and everywhere. But think about that particular poor person who is there in a village, who is not yet aware about the basic rights which was given to that person by way of 1986 Consumer Protection Act. Think about the right given to that particular person under the Constitution in 1950, that is free legal aid or right of hearing. These basic rights are still not reached to the people down the hinterlands. We are talking about data protection. So this is a dichotomous world. We have to think about it from that perspective as well. So I will leave here with you the thought, and you can further nurture that particular thought. If I talk about some more definitions, the law defines digital personal data, and then it defines personal data. And when you say personal data, it means any data about an individual who is identifiable by or in relation to such data, right? So I was having an interaction with the Honorable Vice-Chancellor before I came here, and he had a point. He said that, see, whatever you say, if you share your data with the service providers, then your data is accessible to them, all your data. Even if you delete or not delete, someone at the back end is knowing about you. I said it is fine. But what law is saying is that they should not be able to identify me with the data they have. If they are able to do it, then there is a question. If it is not, then it's probably fine, because we are talking about anonymous data, right? So if till the time that data is anonymous, it is not leaked to me or it is not identified to me, it is perfectly all right. There is no problem around there. There may be some problem, but let us broadly we can say that it is okay. I will give you an example. So when I was doing my LLB, I was also doing part-time medical transcription. So medical transcription is a profession. How many of you know about medical transcription? One of you. Medical transcription, have you heard about it? No? Okay. So during my days when I did LLB, it was a huge thing, right? It was a good thing to do because it gave you a lot of money, and part-time I was doing that because I was funding my studies. And that was a job which was there because of the time difference between USA and India. So in USA, you all know there is a concept of social security number, and everybody has to maintain their medical records. So there all professionals, including health professionals, have to maintain the medical records of the person. So in USA, if you go and find any citizen, you will get complete history of that particular citizen, including whatever shots have been given, whatever medication that person took. So it becomes easier for them to treat the patient. Now, the doctors, they have to make those reports. So every patient they will see, they have to type. Now you all know doctors' handwriting. It is very difficult. If they start writing it, it will be difficult to transcribe it, right? So what is the easier mode? They have a dictaphone and they dictate everything. So that dictation becomes the audio recording, and it comes to countries like us, which has a 12-hour time difference, and there are a lot of people available to do this job. So they hear this and they type it. So I used to do this particular job for about more than 2 years, and I would have seen about more than 5 lakh US citizens medical data, including everything, right? Because doctor dictates everything, right? So if you can think and visualize, you can visualize the person and you just are like a doctor. Including I did a lot of autopsies because I was assigned a client who was an autopsy doctor. So it was every morning I would sit on a computer doing autopsies. Not autopsies virtually, but yes, by hearing it, that what doctor did. So this is something. Now here, imagine this particular question. So was I able to identify that particular person? Probably you can say yes if I did a search for this or try to find out, but I was bound by a confidentiality agreement. I was not supposed to disclose this or discuss this about a particular patient. So this thing will always be there. Service provider will have your data, but what DPDP Act says is you need to protect that. DPDP Act, the baseline is first is consent. There should be a consent of data. You should be given consent. If you don't give consent, your data cannot be processed. This is first part. Data principal has got right to consent or withdraw consent. Second is use as approved. So if you are not approving a use for A, it cannot be used for Y purposes, right? It has to be used for A purposes. This is a baseline of DPDP Act. It says, if you are taking my data for X purpose, you cannot utilize for Y purpose. It is to be specific. So these rights are given under the DPDP Act. Moving further, it talks about personal data breach, and then it talks about processing. So processing of data includes many things, and you can see there are a lot of adjectives given in the definition. It talks about recording, organization, structuring, storage, adaptation, retrieval, use, alignment or combination, indexing, sharing, disclosure by transmission, dissemination, or otherwise making available, restriction, erasure, destruction. Everything is part of processing. Including destruction of data is also part of processing. So data processing right is by whom? It is the data principal, right? Yes, you have a question? Yes, it will come under processing. So if you are giving data to an AI system, that will be also under that particular thing. I will talk about AI also briefly. So I have already talked about this. So these are some of the rights of data principal. It is a bit small. I don't know whether you are able to read, but I am able to read it without my glasses from here. So I don't know. Right of correct personal data, right to access personal data. So you will see in the law, there are multiple rights given to the data principal. And these rights are there for your protection. And definitely whenever there is a right given to someone, there will be a corresponding duty to someone who should be protecting it. And generally in this particular case, there is a whole machinery which has to protect this particular data. So let us look at that. What is that machinery? Okay. So this is the machinery. It is a, these are some of the important people under the data protection law, right? The first one is data principal. So who is the data principal? Who owns the data? All of you, all of us are data principals. Then there are two, people who are very important. One is the consent manager. So as I told you that data which you have can be shared only by way of consent of you. The point is that every day you share your data with hundreds of people, right? Nowadays you are doing that. You go to a restaurant, you share your data. You go to a, you are using your WhatsApp, you are sharing your data. You are in an educational institution, you are sharing data. You go to a restaurant, you are sharing data. You go to book a flight ticket, you are sharing data. You are going, in a restaurant, in a hotel, you are sharing the data. Wherever you are going by a bus, you are sharing data. Wherever you go, you share your data, right? Now, as data principal, whosoever is taking your data, they are bound by some duties under the Data Protection Act. Now to handle this consent, because every time you share the data as per the DPDP Act, there should be someone who will manage your consent. And that is where this consent manager comes up. So who is the consent manager? Consent manager will be a new profession which will be coming up. Right? They are not yet recognized, because once DPDP Act comes up, you will have consent managers, just like your depository participant and many other service providers like banks. These consent managers will emerge. So you as data principal will be giving authorization to your consent manager who will be managing your consent. So as data principal, you cannot manage your own consent, because it will be cumbersome to you, right? You want flexibility. So as user, you will be giving some right, consent to someone, and someone will be managing that particular consent. Generally, what will happen here is that all these data fiduciary will be providing you an additional service of consent managers. So these consent managers are a intermediary. Who are they? They are the intermediary who will be providing you the service of managing your consent. So whenever you will say withdraw my consent, they will withdraw. They will have your consent approval to what extent you have given the consent, right? They cannot breach that particular consent approval. So all these parts will be coming up in the consent manager. Consent manager duties are given, consent manager qualifications are given under the law, and as per that they will be approved as consent managers. They will get a certification, just like your stockbroker or all kinds of other intermediaries which you find in securities market and other places. Then there is data fiduciary. So this data fiduciary will be all bigger entities, right? So these will be educational institutions, hospitals, probably transport services, or restaurants, or maybe Amazon, or whatever bigger players are there. Whosoever is a bigger entity or a business entity, that would be a data fiduciary. They have to maintain that particular data, or they will be processing your data. Say for example, you go to a restaurant, or you are using this Make My Trip for your travel purposes, right? They will have data of thousands of people, lakhs of people. Now, as data fiduciary, they will have so much of a data. Can they process this particular data? Probably, yes. What do you say? Can they process this particular data? So the law provides that they can process it subject to the condition they are not identified to you, right? If it is an anonymous, definitely they will have, the data fiduciary will otherwise go into all this particular mess. They want this particular data. Right now what is happening is they are using this data without your this. Probably Make My Trip shares that particular data on a cost or a money to someone else. This will get prohibited. Now they cannot share this particular data with anyone. But as a service provider, Make My Trip probably will have the information of all. They can put it into a system and get some, what you can say, predictions, or get some information from that particular existing data, or analyzing that big data, they can come up with some conclusion that which sector is having more number of travel, how they should look for it, what is the itinerary of people generally. These are the things which will be dealt with by the data fiduciary. Now, the law also talks about a significant data fiduciary, right? What time should I close? Till 12:30? Fine, is it okay with you all? Right? Okay. Yeah. Yeah. Mm-hmm. No, so all these third parties will be data fiduciary now. Yes. There will be now, after this particular law comes into force fully, there will be no entity which can collect data without falling under this. Yes. So the consent managers, either what would be the role of people? After this DPDP Act, the role of people will be either they will be, all of us will be data principal, and other than that, either they will be consent managers or they will be data fiduciary. So data fiduciary is a larger entity, consent managers are a smaller entity. That is how it is. So it may also happen that data fiduciary may employ a consent manager, or as data principal you may have an independent consent manager, depends. So unethical way, people have to be aware. So you don't have to share. Right now, Richard Posner in US, it is not only a problem of India, by the way. Okay, in US he made a statement long back, and that is referred to in Puttaswamy, wherein Justice Ashutosh quotes him, and he says that people share data at the drop of a hat. And in India, everybody, you go on petrol pump also, there are people who are collecting data on their holidays. I know. The holiday scheme है सर, इसको भर दीजिए, अपना नंबर दीजिए. हाँ ठीक है, ये गिफ्ट है, इसके ऊपर आप दीजिए, अपना नंबर मिलेगा. दूसरे वाला कहता है एक्स्ट्रा में इसके साथ में एक मॉफिन दे दूंगा, उस पर लोग डेटा शेयर कर देते हैं, नाम और नंबर. सो इट इज, see, till the time, there will be this is a transaction, right? So say for example, I am asking you for a data, which does not itself amounts to criminal action, right? Because criminal law has 4 stages, right? This will be just at the initiation stage, which is not punishable in law. But till the time you give me the data and I misuse it, criminal law doesn't apply. So point is here that you as data principal have to take a call. If someone has misrepresented and get your data, then it will be a criminal offense, because it is misrepresentation, criminal breach of trust, or that will fall under the criminal law, not under data protection law. Data protection law says lawful given data being breached. If you have given a data lawfully to someone with a particular consent, say for example you gave data to X company who is a data fiduciary for A purposes, and this company utilizes for B purposes, then there is a data breach. If their system got hacked and then data got leaked, that is a data breach. So DPDP Act also provides for the data fiduciaries to make systems stronger. They are saying that you have to make your system stronger. You have to make sure that you have all technological know-how and technological aspects to protect your data. So that is mentioned in the law. Okay. Then I was talking to you about significant data fiduciary. So the law prescribes additional duty on significant data fiduciary. These are in 3 categories. One, which deals with gaming, online gaming, then social media, and there is one more category which deals with, I think I have put it somewhere. Just a second. I'll come to that in a while, because I wanted to talk something more on that. And then there is data processors. So these are the people who will be processing your data. So there can be entities who are data processors. Okay. Now, Data Protection Board of India, right? So Data Protection Board of India will be formed, and this, I think, process must be on because it has to be formed in 1 year. Probably November 2026 is the deadline by which it should, as per the rules, notified. So this will be the body which will be looking after all your grievances. So if there is any breach, any challenge, they will make rules, regulations, they will be monitoring the data protection regime in the country. So we are looking forward to it. Law is interestingly says that it should maintain a digital office. So probably everything will be online, and everyone will be, now I'm really worried about the person in the hinterland. You remember? I told you somebody is there. So we have to see that how this data protection board will reach there. I don't want to sound like Devinder, he said once that how the things will work and all, but I hope things work properly under this particular law to everybody's benefit. This is the rules which is notified on November 2025, 13 November 2025, and you are able to see there are 3 phases in which the digital protection rules will take into shape. So the first phase is that data protection board and commencement has already started, and that is 13th November 2025. Second point says about registration and obligation of consent managers. So we are likely to see consent managers getting notified by November 2026. When once board is there, they will probably register a lot of consent managers. You will have consent managers in place. And then the remaining portion, which is of penalty, liability and everything, will come up somewhere around 13th May 2027. That is the deadline for this law to be in force completely, right? The Ministry of Electronic and Information Technology that is dealing with it, that is MIT. And for you people as lawyers, which will be the forum which is very important, you should start reading now if you are really interested in this particular area to practice, is Telecom Regulatory Authority of India, TRAI, Act, and TDSAT is the tribunal where these cases will go up. All these cases will be going to TDSAT. Interestingly, this particular law has taken into consideration the suggestions given in Roger Matthews' case. So if you have a if you read Roger Matthews' case, this talks about tribunalization of justice in India, and it has made a suggestion that you should not have a lot of appeal from there to Supreme Court. If you see the modern tribunals, the appeal goes from tribunals to Supreme Court. Many tribunals, right, including NCLAT and this insolvency as well as many other tribunals, appeal goes to Supreme Court. Now here, they are providing that the TDSAT order will be considered as a decree of the court and it will be enforceable. There is no appeal provided beyond TDSAT, so it has to be closed there. Definitely, Article 226 and 32 will still remain. Anybody who has a challenge there, where they will be going there. So, who can be consent managers? So, there are some qualifications given for consent managers, which we will be seeing somewhere around November. So, they have to have an incorporation. They must be a private or a public company, society or a trust, but they must have a minimum net worth of 2 crore rupees. And there should be a governance framework. There should be a proper board of directors and managers. These all qualifications are just like any intermediary of securities market. So if you see securities market intermediaries, they have similar kind of a qualification. And only some things are important here, like for example, technical infrastructure. So it is saying that consent manager must have technical infrastructure to protect the data of people. They should have that all security mechanism. And they have also mentioned that data encryption standard, like AES 256 minimum. And then prohibition of dual roles, they cannot do both the data fiduciary and consent manager role. And non-discrimination, transparent pricing, they should not have any undisclosed benefit that you collect data and then earn something else from there, share data with political parties and take it. Cambridge Analytica case you people may be aware about. So these are significant data fiduciary, as I pointed out to you. There are 3 classes. The first one is e-commerce companies like Amazon, Flipkart, these companies will come here. And the threshold is 2 crore people must be logged into them. Second is online gaming with 50 lakh registered users. And then social media is not less than 2 crore rupees. Now here I want to put a point to you people, and this is a comparative point. If you see, the government came up with this IT Act ethics rules for social media users in 2021. You know, and that Twitter case came up, right? Where Twitter objected to it, and then the law minister made a statement that any company who is operating in India has to conform to the laws of the country, and there was a lot of hue and cry, if you remember that, right? So there, this particular law, at that point in time, it provided only 50 lakhs, right, as the significant social media intermediary. But under the DPDP law, this 50 lakh is 2 crore. Okay, so there is a disconnect here, which I feel should be addressed, because both should have same thing. But I think this will be getting addressed over the period once it gets enforced. Significant data fiduciary has got an additional role of data impact assessment. So they will be doing data impact assessment also, that how their systems are performing, whether there were breaches, whether there were too hate posts, whether child pornography got promoted on their website, or any such kind of issues. They have to do this particular data protection impact assessments. And this is the schedule of penalty, huge penalties under the law. If you see, 250 crores is the penalty. Everybody must imagine 250 crores is a huge amount, right? Have you seen 250 crores? Not before. No, in the law you must have seen, but it's the first time I am seeing 250 crores rupees as a penalty. Till 25 crores I saw, and I'll tell you my story. I was in Competition Commission of India, and you all know, if competition violation, if say for example Competition Commission gives an order and someone doesn't follow, what is the remedy? Yeah, anybody is competition law student here? You have not studied competition law? Yeah? Yes, you want to say something? Execution petition. No, there is no execution petition as such, but there is an individual liability. So you can bring that particular person before the Chief Judicial Magistrate, okay? CMM, and it is Delhi CMM. An individual case can be filed, and that is a penalty. It means there is a jail and penalty of 25 crores. That is the penalty. So when we filed the first case, we went to the CMM. You know what is the jurisdiction of CMM in Delhi court? How much? They never saw 25 crores, by the way. Huh? It is much less than that. Otherwise, it goes to High Court, that particular matter. So, when we made an argument, sir, you have the power to impose 25 crores. Oh, yes, 25 crores? And then you have to actually explain the complete law to them. That yes, this is the law and this is how it is. So, sometimes law is made, but the implementation is difficult. So this is 250 crores, so it is huge. So we will see how it works, and probably it will get sorted till TDSAT. So this is the penalty. And there is another important, this section 30 I have already talked about. This is that there is the cases will end at appellate tribunal as executable degrees. But in India, getting a degree executed is a huge thing. It takes a lot of time. So I don't know how they are going to solve it, but there is also a provision of alternate dispute resolution. And thankfully they have said that it is talking about only mediation, not arbitration, by the way. So it is saying that you should solve it by way of mediation. You all know that Mediation Act has come up. We are yet to see the final enforcement or full enforcement of that law, but looking forward to it. I end my presentation here. And I have something else which we can deliberate and depends on your interest. So I will open my floor for questions. If you have any questions, I will be happy to answer first. And then if you are really interested, then I will talk about this free AI committee. Yes, questions. Yes, please go ahead. Can we have a mic with him? Or yeah, here. Yeah. Yes, go ahead. Hmm. It's a wonderful question, actually. And this question got deliberated in Justice Puttaswamy, if you see. And they have said that there has to be a balance between the right to privacy and, freedom of speech. So if your freedom of speech 19(1) is confronting with Article 21, Article 21 will have precedence over 19(1)(a). This is what the judgment says. So there has to be a balance, and who has been given the power to arbitrate on this particular issue is government. The government on a larger interest, because who is the repository of public interest? It is government, right? So if the repository of public interest is not individual, by the way. You may have a different view, I may have a different view on an issue. Government, when they took a decision, they take a decision in public interest, isn't it? Right? Whether you agree or not agree, that is a different story altogether. Yes, so timing has been reduced. That is what you are saying, or increased? 3 hours only. Because if the damage is done, then who will look at it? I will give you an excellent example on this. Read the decision of this Pawan Khela, the latest controversy, right? Now, quite interesting discussions are happening on that particular thing. I have a very different view on the decision given by the Supreme Court in that particular case. But you see the controversy. It takes not even 3 hours. It takes 15 minutes to flare up something, right? In this particular age, particularly if it is a hate speech, if it is a rumor mongering, or if it is a any information, particularly in case of pornography or where women are involved. So this is the ground on which the state is working. So somebody may say that state is utilizing the feminist card to bring this particular change, but overall it is public interest. Yes, they are doing that. There is no, with all political parties, it is happening like that. So if you see, but that is why there are courts, right? You have remedies for that. If you feel that no, this has been done illegally, nowadays courts are sitting at midnight also. Obviously in appropriate cases, right? Yeah. Any other question? Yeah. Yes, please go ahead.
The consent must be informed. If you see the contract act, then it mentions that consent must not be requested. So if I see the WhatsApp or any other website, there is only single line. There is the privacy guidelines.
Correct.
So I can't read, like I need to apply something 5 minutes. I only have 5 minutes. I can't read that whole 50-60 pages in 5 minutes. So is it
no, but why you want to accept in 5 minutes? You accept it in 5 hours. What is the urgency?
the urgency?
This is not life and death situation, right? So if you say, for example, you are entering into a WhatsApp contract,
enter it after 5 days. What is the problem?
Only the WhatsApp. They are also taking the data. So commercial usage.
Yes.
Data. It's given by.
So what's the name?
Piyush.
Piyush. So Piyush, basically, you will see the DPDP Act brings forward this dimension clearly, that when you are taking consent, consent has to be very, very specific and in a readable format. This change they have brought it in this. So if you see DPDP Act, it is saying that from whomsoever you are taking consent, it has to be, consent has to be procured in their language their understandable language. It should not be couched in words. This is what is very clearly written in this particular law. So probably this will bring some relief to the people. Yeah. Yes. Go ahead. What else? Yes.
Sir, I have a doubt that all these data fiduciaries, most of them, we perceive that they are private institutions or private companies. Sir, but I have a question that most of our data, like health, personal, biometric, is with government.
Correct.
And nowhere it's like publicly available that how government is using it, because there is a large loophole that there's a possibility of predictive policing or AI being used right now. So how does DPDP Act uses and helps us?
See, you have to see that there has been always, confrontation between citizens' right and the state's power, right? So if you see all the decisions, particularly in Puttaswamy also, or Aadhaar judgment, if you see Aadhaar judgment, in that is why Aadhaar is not made mandatory for doing a CBSE course or a university degree now. Why? Because they said that this is not mandatory. The state should not be given this particular, power, that much of power. But if you ultimately see, now we will be doing census. Census law will collect all kinds of data that will be given, including your caste data and all those data as is being contemplated. So these particular data, state will always have this particular data. The question here is that whether they will be utilizing this data for X purpose or Y purpose. Your concern is that. Your concern is not collection of data. Your concern is that misuse of that particular data, whether state will be misusing it against you.
So like in Israel, when we see there was a college student and in her WhatsApp group, she just jokingly said that Netanyahu should bring some donuts for me and my friends. And actually now she is being prosecuted because of defamation and security concerns in Israel. So
this has happened, if you look at it, these same things happen in India also, but courts have stepped in, like Shreya Singh's case. This is what exactly happened in Bombay, wherein against Shiv Sena leader somebody told and then she was arrested. Similar things happened in Bengal when Mamata Banerjee was told on certain points. She was arrested by Calcutta police. The perpetrators were arrested. Similar kind of events has happened in South also at many places. So you see the power which people wield at that point in time, they try to misuse, but for that purpose only you have courts in place, right? And you people as harbinger of rights would be there to protect rights of people. That is what is the training given in the law schools to all our students, to protect the rights of the people. So there has to be a balance. But to look at extreme, if you look at it, say for example, the government is told not to collect any of these particular things. How do they work on it? Somebody told, recently you must have got this disaster management notification on all your mobiles. Now some people got irritated with that. Who gave them this particular right to irritate us? Okay, fine, if there is an earthquake, then don't ask government, no? Then you cry about that, yes, government is not doing anything. They should have given everything. They are not aware about our problems. Now when government is asking you that, yes, tell us about your problems, because unless we have data, because see, planning cannot happen without data. One of the major drawbacks of our country is that our country doesn't have authentic data. Anywhere you go. And that is a major problem. That we need to sort it out. We are still struggling that who is our citizen and who is not. And this is a huge question. Somebody may look at it from a political angle, from a question, but I am looking at it from a security angle. As a citizen of this particular country, I should be sure that the fellow person who is there with me is also a citizen of this country and has got similar kind of rights and duties. Right? So that particular, assurance I must have. Yes. Anything else? No other question? Okay. So I will leave this particular floor to you with two thoughts. Since we are in Haryana and I was reading this judgment of Puttaswamy, and Justice Sanjay Kishan calls, interestingly in one of the paragraphs, quotes Gita. Okay, I don't know how many of you have read it. Anybody could read it? Kisi ne padha hai? Nahin. So he says, it is wrong to consider that the concept of the supervening spirit of justice manifesting in different forms to cure the evils of new age is unknown to Indian history. And there he quotes, Lord Shri Krishna declared in chapter 4, text 8 of the Bhagavad Gita, Paritranaya sadhunam, vinashachaya dushkritam, dharma sansthapanarthaya sambhavami yuge yuge. This is what he says, and he then elaborates this, and he says that from generations to generations, things have transformed over the years, right? And in every generation, there will be problems which will be coming up, and there will be people who will be coming up to solve these particular problems. So if you see 1954, when we had this particular decision of MP Sharma by 8-judge bench and subsequently by Khadak Singh in 1964, these decisions were right at that point in time. But when we are living in an informational age, when we are living in an age where data can be transferred instantly, we need newer tools and newer ways of looking at it. Probably one of the major things which we have to do is to, educate. Advocacy is the larger thing which needs to be done. More and more people should be aware about their rights as well as their duties. And that is very, very important aspect. There were two things also quoted in this particular decision, and I leave this particular thought to you. One was Anuj Garg's decision in Hotel Association of India, and this case was quite interesting because it talked about the restriction of women in serving as bartenders, right? Now somebody may say that whether it is a progressive decision or regressive decision depends in which society you are talking about it, okay? So that was questioned from a feminism perspective, that nobody should be restricted just because they are of a particular sex from a particular work, right? This is what was held in this case. Another case which dealt with Hinsa Virodak Sangh versus Mirzapur Moti Quraish Jamaat. This was relating to slaughterhouses and ban of slaughterhouses for 9 days during Durga Puja, right? So this particular case actually brought forward a very interesting dimension of privacy of eating. So you must have seen in our country there is a lot of debate which has happened on eating a particular dish, right? So probably in the Bengal elections recently you must have seen fish going around, a lot of, I don't know how many of you eat fish, but that was quite an interesting debate. So in this particular case, the court has said that what one eats is one's personal affair and it is part of his right to privacy. Now, this is a dimension which has been talked about. However, in this particular case, court held those 9 days of restriction not, as appropriate. They said that if it would have been a longer period, we would have looked at it otherwise. But since the restriction was only for 9 days, probably it is okay. There is a question on this, by the way. There will be both sides of the argument which can be there on this. So I am leaving here to you a number of questions actually, right? So I hope you people all deliberate on that and probably we meet again. Thank you.
Thank you very much, sir, for this insightful, comprehensive and enlightening lecture. We are truly enriched by your profound expertise and practical perspectives on the DPDP Act 23. I now request our faculty coordinator, Dr. Parul ma'am, Assistant Professor of Law, to propose the vote of thanks. Ma'am, over to you.
Thank you, Yash. Respected sir, my esteemed colleagues, Shruti ma'am, Pankaj sir, Sumit sir, and my dear students. It is a proud privilege to extend a vote of thanks on behalf of this organizing committee today. Today's lecture on DPDP Act has been both enlightening and thought-provoking, and we are deeply grateful to our distinguished chief guest, Professor Dr. Vijay Kumar Singh, Dean of the Faculty of Law, SRM University. Sir, this occasion is especially meaningful for me. As my PhD mentor, you have guided me with wisdom, encouragement through all my challenges, shaping both my scholarship and my outlook as a teacher. Organizing this lecture has been a long-awaited aspiration for me, and your presence today has added immense value to our understanding of this act. On behalf of all the faculty members, students, and the organizing team, I express our sincere gratitude to you for sparing your valuable time and sharing your expertise with us. I also thank all the students for their active involvement, which made this session engaging and fruitful. With that, I once again extend my deepest thanks to Professor Dr. Vijay Singh sir for gracing us with his lecture. Thank you so much, sir. Thank you all. Thank you all.
Thank you.
Thank you, ma'am, for the warm and gracious vote of thanks. So this brings us to the successful conclusion of today's expert lecture. Once again, we extend our heartfelt gratitude to our chief guest, our dignitaries, faculty members, and all the participant students for making this event a success. Thank you.
You have taken consent of it. Now, see, there will be a challenge of these photographs also. So I have been to European Union and many other places. There is a specific warning at every place in conference hall. We have seen that there are warnings displayed that this is a public event. You may be photographed, may be used. If you have any objection, then please meet at the reception desk. There is a form which they give you, and so this is the level of protection. I wish in our country it will take a lot of time. So we can celebrate with this law that yes, this has come up, and we should be all happy that yes, we have data protection now. But imagine that how it will translate on the ground. Give you one example that goes a quite live example. So I have a car, go to service that particular. Went to the service station, car is serviced. After that, you have to give a feedback. Right? You all give a feedback at all places. You are free to give your feedback, right? So I gave a feedback 8 out of 10. 8 out of 10 is a good score, isn't it? Though I am a very strict marker, but 8 out of 10 I consider it is 80%. Good. Then there was a call which came back. Question was, sir, 2 number kahan kaat diya? So that we can improve. Question came up like that. You want to improve, and you tell us. I said that your car was not washed properly, and I think that washing needs some. Okay, sir. We will give you the service again, and you come and get your car washed, and please give us the rating 10. Okay, fine. When you wash, then I will give 10. Not now. Bothered me like anything. So then we gave call so many times to get the car washed. Again, I went this time for the service. Same issue. Has not changed. So service conditions in our country, particularly as a consumer, is a huge issue. We have to actually look at it. That whether these things, when we are talking about consent managers, if they breach, how many people will be able to, go to the level of confrontation in the courts and getting their remedy, and what will happen to this 250 crores? Don't know. How it is. So these are all challenging times. Probably you all will witness it live and fight with this. So be prepared with that. I think this law has a huge potential for everyone, because you will be working in any organization. This law will come. Definitely. Need to work. Yes.
Please email for attendance. 30th class.
फर्स्ट ईयर थर्ड ईयर की हुई नहीं, थर्ड ईयर की हुई नहीं है तो जा अगर थर्ड ईयर की
फर्स्ट ईयर कितने थोड़े से हैं? रोल नंबर ही बता। सेक्शन बी की पंकज सर ने ले ली। सेक्शन ए का ग्रुप में है तो बता। सेक्शन बी की पंकज सर ने